Hello, everyone. I'm Andrew McKenzie. Welcome back to our weekly webinar. Here, I'm going to be talking about liquidated damages, different kind of damages. And we're going to be exploring the question of whether your liquidated damages clause is or is not enforceable. So first, in order for us to get started, I think we need to talk about what liquidated damages are. So in general terms, they are a sum of money or a set formula to calculate the amount of money which a party will owe if it breaches a contract to compensate the injured party for its losses. Now, keep in mind, normally in contract law, when somebody breaches a contract, they have to prove actual damages. So, for example, let's say you have a lease and you're a landlord, your tenant breaches a lease. You need to prove that you lost money on account of them breaching. If they vacate early, were you able to find another tenant quickly enough to fill that space to mitigate your damages? Or were you not trying hard enough to find another tenant? That kind of thing is typical in needing to prove your actual damages in the event of a breach. So liquidated damages are an exception to that rule. And here's some of the background on that. Liquidated damages developed as a concept in English common law back in about the 1400s, and it developed over a number of centuries. The concept of penalizing somebody if they breached a contract had been around for a long time, but English courts of equity decided, that might not be so fair. The goal of enforcing contracts is to put the non-breaching party in as good of a position as they would be in had the breach not occurred. But if we give them more damages than they would be able to prove, there's something really unfair about that. By the way, I'm struggling with a cold, so if I cough, I apologize for that. But here's a really great quote from a commentator who offers an opinion and some insight on how we ended up getting the concepts behind liquidated damages clauses. It is characteristic of men that they are likely to be beguiled by the illusions of hope and to feel so certain of their ability to carry out their engagements in future that their confidence leads them to be willing to make extravagant promises and commitments as to what they're willing to suffer if they fail. You've probably experienced something like that in your personal life. Someone might have said, oh, I promise I'll do such and such for you. And if I don't, I'll give you my right arm, or I'll pay you $1 million, or whatever outrageous thing they might say to assure you that their promise is good. The problem with that is that when a breach does occur, you may wind up way better off than if performance had occurred under that kind of penalty provision. And English courts of equity recognized that that was not a good way to go in enforcing those kinds of deals. So over the course of a number of centuries, they started to develop rules as to when those kinds of provisions are or are not enforceable. And there's a concept in law called unconscionability, which can be a defense to a breach of contract. If a provision is unconscionable, that it shocks the conscience of a judge or normal people in society, then it should not be enforced. So if I say, I promise I'll make my mortgage payment next month, and if I don't, you can come and take my right arm, that would not be an enforceable promise. So the purposes of liquidated damages clauses are mainly twofold. One is to motivate performance of the contract, and two is to dispense with the requirement to prove actual damages. So In the Restatement Second of Contracts, which is a very well-known and relied upon treatise of contract law, there is a specific statement in there that says, this lays it out very clearly, parties to a contract are not free to provide a penalty for its breach. Penalty, of course, is when you go beyond what the actual damages are and provide a windfall to the non-breaching party. So there's liquidated damages clauses are found in a lot of different areas of daily life. A typical one that we deal with frequently because we do real estate litigation is earnest money forfeiture in real estate sale agreements. Probably nearly everyone in the audience has heard of earnest money deposits. That's basically a good faith deposit that a buyer makes when they're wanting to purchase real property. And they are basically saying, hey, I'm serious. I'm a serious buyer. You could take me seriously. How do you know that you can take me seriously? Because I'm pledging to you that if I breach this contract, you can keep my earnest money. So sellers are evaluating offers from different buyers. The buyer that puts up more earnest money might very well be taken more seriously than a buyer who's not willing to put up as much. The seller can feel more assured that that contract is going to go through and the transaction will close. You've probably made a travel reservation at some point in your life. Have you ever heard of those kinds of situations where the host or travel provider says 50% is due up front? I'm going to collect the other 50% 10 days before you travel or 30 days before you travel. Typically, those kinds of arrangements involve a liquidated damages clause embodied in the agreement to make the deposit. And if the deposit gets forfeited, then the host for that travel reservation is, in effect, collecting liquidated damages. Now, those provisions are not always enforceable, although in reality, most of the time people do not contest them. They usually walk away from the money that they have forfeited without claiming that the provision was unenforceable. Construction delay damages are another very common contractual provision that you find in real estate law and commercial litigation. People who hire a contractor to build a building or renovate a building or do whatever usually have a vested interest in making sure that the project is completed sooner rather than later. You might not be able to rent your building out to tenants until certain repairs are made by the contractor. Those kinds of things are common. And so a liquidated damages clause is very likely to be found in a construction contract. Early lease termination clauses. Personal story of mine, years ago, I rented a house. I was the tenant, and I terminated the lease before the 12 months was up. And the landlord kept 1 month worth of rent, which I thought was extremely unfair. But it was not worth my time to fight over it, so I moved on. But that kind of a clause, they called it a break lease fee, is an example of a liquidated damages clause. Most people have borrowed money at some point in their lives. It might be a credit card, might be a mortgage, or might be some other kind of contract where you promise to pay somebody a particular interest rate. Those contracts frequently contain provisions that bump up that interest rate to something far less favorable to you if you breach. And the goal, of course, is to incentivize you to continue performing. Now, in all of the examples that I've just listed here, the liquidated damages clauses may or may not be enforceable. So just because it falls into one of those categories doesn't mean it's automatically enforceable. So we're going to take a quick look at common law requirements for enforceability of liquidated damages clauses. So the two big requirements are, first, the amount fixed to be paid has to represent a reasonable forecast of just compensation for the harm caused by the breach. So, for example, let's say it's a contract for the sale of a $100,000 manufactured home. And you have a clause in that contract that says if the buyer backs out, they pay $100,000 to the seller. That would almost certainly not be reasonable, would not be a reasonable forecast of just compensation. That mobile home, even if you back out of the contract, is almost certainly still worth something, and the land that it sits on is worth something. So the seller in that situation cannot reasonably argue, hey, we reasonably anticipated that if the buyer backed off, I would suffer $100,000 of damages. So the second big requirement is that, generally speaking, a liquidated damages clause will only be enforceable in situations where the parties at the time of contract would not be easily able to determine the likely amount of damages that the non-breaching party would suffer in the event of a breach. So it's interesting because there's a reasonable forecast requirement where you're trying to figure out a reasonable range of what those damages might be, but there's also a requirement that they can't be precisely determined at the time of the contract. So those two requirements are a little bit in tension with each other, but you got to keep those in mind when you are evaluating whether one of those clauses is enforceable. 20/20 hindsight is a common issue with liquidated damages clauses. Frequently, there is a divergence between what the parties would reasonably have forecast were the damages to be incurred by the non-breaching party and what the actual damages suffered by the non-breaching party turn out to be. So even though it's not per se unenforceable if those two numbers are different, the court is allowed typically to consider that delta between the actual damages suffered after the breach happens and what the forecast was at the time of contracting of what a reasonable range of likely damages would have been. So if those two numbers are too far apart or greatly disproportionate, the court is more likely to find that that provision is unenforceable. It can't be punitive. As I said earlier, parties are not allowed under the law to contract for penalties. Now, there are some statutory exceptions to these common law contours of liquidated damages clauses. One of the big exceptions in Washington has to do with real estate contract earnest money deposits in a purchase and sale agreement. So this particular statute, RCW 64.04.005, shields sellers from an attack on a liquidated damages clause if the amount of damages fixed in the contract for forfeiture of the earnest money is less than 5% or up to 5% of the purchase price. So if it goes over 5%, you can't use this statute. It doesn't mean it's automatically unenforceable, but it means that you can't use this statute. If you're 5% or under and you're a seller, you can rely on this statute to require that the earnest money be paid to you in the event of a breach. Another big exception that I've not mentioned here on the slide has to do with real estate contracts. Now, that's a little bit different than a purchase and sale agreement. A real estate contract is when a buyer and a seller agree that the buyer will purchase real estate over time and not actually obtain title until the purchase price has been fully paid. It's a little bit different than a typical real estate transaction, but it is alive and well in Washington State. And it is one of the few areas of the law where courts allow, and the legislature has allowed, forfeitures and penalties. In other words, you can have a situation in a real estate contract where you make almost all the payments, but right as you're nearing the finish line to be completely paid off and get title, you fumble the ball and somehow you end up breaching contract with the seller. If the seller follows proper procedures, There can be a situation where you get nothing and the seller gets to keep all their payments and gets to keep title to the property. So that's one reason why, as a general rule, I don't recommend to buyers that they enter into real estate contracts. So we're going to look at another slide that I've developed. This is a visual representation of contract provisions. You can see here in the big chunk here, enforceable provisions, breaches which require proof of actual damages. This is intended to be a visual representation to illustrate the fact that almost all of the time, you must prove actual damages if you want to collect damages for breach of a contract by another party. But over here in this column is a category of breaches that don't require proof of actual damages. So I've put here in green, these are unenforceable provisions. Doesn't mean that you should ignore them. You should be aware of them, because sometimes people may attempt to include a liquidated damages clause in a contract when it's not actually enforceable. It may have the appearance of being enforceable, but ultimately it does not get enforced if it does not meet the requirements. And then here in the blue box at the bottom of the second category is enforceable liquidated damages clauses. So that's the primary subject of today's conversation. I'm going to give one quick case study to illustrate how this principle of liquidated damages and analysis of whether clauses are enforceable has come into play in real life, in real practice. This is a case that I litigated about a year and a half ago. There was a dispute between husband and wife who were divorcing. They had entered into a property settlement agreement that was heavily in the wife's favor, and it included provisions that the husband could get the family home, or the majority of the family home, so long as he made certain payments according to a payment schedule to the wife. And it provided that in case he breached, if he missed one payment, if he was late just by a day for one of the payments, that he forfeits all the payments that he's made, and the wife gets 60% of the interest in the house, including 60% of the sales proceeds, and can force it to be sold to a third party. So by the time I really got ramped up on the case, it was too late to stop the sale of the property to a third party, but it was fair game to fight over the proceeds and who was entitled to get what. We successfully got the court to strike the unenforceable penalty provisions in that property settlement agreement. It's an interesting case because this was a property settlement agreement that had been incorporated into a court judgment. It made it that far. And the other side tried to argue, hey, husband agreed to this. There's nothing more to talk about. And we had to really hit home the fact that, look, just because you agree to it doesn't make it enforceable. This concept, remember, parties are not free to agree that penalties will occur in the event of a contract breach. Okay? There are other areas of the law where penalties can attach. They can be criminal situations. They can be tort situations like a car accident or negligence, those kinds of things. There can be punitive damages or treble damages for things like timber trespass. But when you're talking about contract law, penalties are not allowed in Washington and in most jurisdictions in the United States. So in that case that I mentioned, the court ordered the wife to pay back hundreds of thousands of dollars in sale proceeds to the husband as a result of the fact that those penalty provisions in the property settlement agreement were unenforceable. So it was a really huge deal and a good illustration for why it's important to understand the contours of liquidated damages. If you are considering entering into a contract that includes or might include a liquidated damages clause, here are a few quick tips for you to keep in mind. First of all, it's important to know what liquidated damages clauses are. Some people think that they have to be only about money. My personal opinion, although I've not been able to find any explicit authority about this in Washington, is that property ownership or can substitute as actual money to qualify for a liquidated damages clause. In other words, if the clause says you get Andrew's house if you breach, or if I breach, you get my house, I'm not handing you a pile of cash, but that house clearly has a market value. And so my argument, my personal opinion is that kind of a provision would certainly be a liquidated damages clause and would almost certainly be unenforceable. Do not assume that all provisions in a contract will be unenforceable, will be enforceable, even where parties freely negotiate and are represented by counsel. Yes, that can be a help that both parties are represented by counsel, but a penalty clause is a penalty clause. It is not analyzed based upon whether parties are represented or how much they negotiated. It's analyzed on those two factors that I mentioned before. Is it a reasonable forecast of the damages? And are those damages difficult to determine? You've got to meet those two requirements. Otherwise, that provision is likely going to be seen as a penalty. Don't use the word penalty in a contract. That just sets you up for much higher likelihood of failure if you're trying to have that provision be enforceable. But here's the really big thing as far as drafting. Make sure that you recite and stipulate to relevant facts that justify the liquidated damages that you are agreeing to. So, for example, if I want contract delay damages, instead of just saying each day that contractor goes past the due date for completing the building, contractor shall pay owner $1,000. Instead of just saying that, the better way to do it is to recite some of the facts about how and why and how much the owner is going to be losing on account of that delay. For example, you might include a recitation in that contract that says, owner has lined up tenants to fill the space starting on such and such date. Tenants have signed contracts with owner to commence occupying the space and to pay rent starting such and such date. In light of this, owner and contractor agree that owner would be greatly damaged if owner is unable to complete the building by the due date, blah, blah, blah. That's an example of the kinds of recitations that you might include to help ensure that if a dispute brews later on, you will be able to enforce that liquidated damages clause. So I hope you've enjoyed this presentation. We are here for you to help. Please reach out to me at the email address I've shown here in this slide. If you would like assistance in Washington State or California in a commercial litigation context or a real estate context. Thank you so much, and we look forward to hearing from you.